I don't know. After hearing him calm and talking about the tether story, it's probable.
Please go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. I had the other window playing and I couldn't tell if it was an echo or what was going. But hey, what's going on? Everybody, I'm kind of testing my network on this one, and I already see the network quality's dropping. So hopefully it stays well. I got a lot of people saying that my RAM is the issue, so I everything closed on my computer except for this window. So, and the window that I was talking to. A second, you know what? Let's just close that. All right, that's closed. All right, so we're testing. We're testing my everything on this. So hopefully it works well. Little, probably too much information. Hello, everybody. Welcome. I am feeling a little bit better for the people that were asking. I felt better throughout the day, and this is why I think that it was just allergies, and I'm, didn't actually catch anything serious, so we're doing well. First clip, Judge McConaughey. It's a tough one to hear. It's a tough one. There's a lot of serious accusations going around, and we're going to find out. We're going to find out. I'm going to follow this case, though. I have already done research into this, and I've got a lot of things I want to say about it, but I'm not going to yet. So we're just going to watch, and we're going to learn. But like I said, I'm testing out a few things with my network and my computer to see if this makes the connectivity a little bit better. So if you can hear me more clear and you aren't in the chat and you hear this later and I sound more clear, just leave a comment saying this setup works well. That's all I need to hear. All right. You guys ready to hear a serious case? Because these aren't funny. Neither of these cases that I have to show you are funny. So let's go. But before I hit the play button, you already know what to do. Hit the like and subscribe. And do your jump backflips. All right, let's go.
Calling case 230-596-9901, People of the State of Michigan versus Philip Lewis. Defendant is charged with count 1, weapons, firearm possession by a felon. Count 2, weapons, ammunition possession by a felon. Count 3, attempted peace officer disarming. Count 4, weapons carrying concealed. Count 5, police officer assaulting, resisting, obstructing. Also count 6. Count 7, weapons, felony, firearm, third offense notice. Count 8, weapons, felony, firearm, third offense notice. Also count 9 and 10. Defendant is labeled as a habitual offender, third offense notice. Today is the date time for a bond redetermination hearing.
Judge, good morning. Steve Benson for the people.
Your Honor, good morning. May it please this honorable court, Philip Reagan, P57156, on behalf of Philip Lewis, who's appearing via Zoom from the Wayne County Jail.
State your name, sir.
Philip Lewis.
Argument.
Judge, I don't know if the court has had an opportunity to review
I have.
the investigator's report, Judge, but I would ask that you bear with me a little bit here. My client, Judge, he's 41. He does have some priors, obviously, as you can see. But, Judge, when I read this report, it kind of reminded me of something on TV. And I'm looking at it from the fact that allegedly you have a person in a burgundy car that pulls up behind a fully marked police car and starts to fire, I guess, shots in the air, shots, I don't know where, just fire shots. And then this burgundy car.
Please tell me you're joking. Please tell me that's not true. Can you hear the clip? Don't do that to me. Phil, don't do that to me. You're one of the people that I would listen to. Now I gotta wait a second before I hear. You guys can hear the clip, please? All right, I'm just gonna keep playing it because I think he's messing with me. Phil, tisk, 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 tisk.
Decides to leave from behind the police car and I guess go a couple blocks to the Coney Island, allegedly, and just park and get out and go and get in line and get a Coney. Now, what's really ironic about this, Judge, is you said the police say that they follow this car and they lose sight of the car, right? But this is a car that, right, that's allegedly fired shots right in front of them. So what do the police do? They say, oh, there's a burgundy car. They get out and they go into the establishment where they think that a person who just shot may be. So they see what they think might be a imprint of a gun in a shirt. But now this is a person that they may have thought may have just shot in the air. But what did they do? Did they draw guns, ask the person, hey, sir, get down, you're a suspect, get down? No, they just say, excuse me, sir, do you have a CPL? And this is how they proceed when they just allegedly got shot at a few blocks away. I don't buy a lot of this stuff, Judge. So then they ask him, and the gentleman is like, well, I don't know what you're talking about. What's going on? He tries to walk away. No, sir, come over here. You're not free to leave yet, And it's like, it's amazing to me, Judge, how these write-ups are written. And all of a sudden, my guy has a gun, but they don't try to secure this gun initially. They don't do that. They just immediately start grabbing at him. So then he starts to grab, I guess, at their guns. He has a gun of his own, but I guess he says, I don't want just use my gun. I want your guns too. So while he has the gun in his waistband, he starts grabbing for their guns. Then once they get him, I guess, a little bit secure, then they say, oh, then we'll remove the gun from his waistband after that. Then I guess he starts to grab more guns, Judge. I'm not buying a lot of this, Judge. I think that my client, unfortunately, may have had a gun on him. He was not eligible to have one, allegedly. And, he's here today because of that, Judge. Now, I'm not saying that he had the gun, but if he did, he shouldn't have had it. But I don't think that he did any shooting at police. I don't think none of that stuff. I think he's a person that had a gun, Judge, that was not eligible to have one. And that's why we're here. We have all these different charges, Judge. I think this is kind of crazy. Go ahead. I'm sorry, Judge. I know you want
just to make sure I'm clear, though. He's not accused of the shooting that happened when the officers were talking. He wasn't accused of that, though, right?
No, Judge. He's accused. He's accused, Judge, of trying to disarm a police officer
in the Coney.
In the Coney, Judge. In the Coney. Right. But yet, they have to have as Brother Counsel was going to say, they have to have the flavor to set the tone. They set the tone with the shooting. Why they could even go in the Coney and ask him that question? Why would you even walk up to somebody and ask him, do you have a CPL?
Well, I guess because they could clearly see the imprint of the gun. This is what they're saying. But
that doesn't mean you get to ask. I don't care if you see an imprint. I don't see anything. They don't know if he has a CPL or not. He didn't commit any crime.
Well, he's not open carrying though. The gun is concealed. So if you see a concealed weapon, you can ask to see. I mean, you can ask to see it.
Right.
But
he has the right to walk away. You're right, Judge. He has the right not to answer the police, and he can walk away. He can walk away. But in this particular case, and they do have every right, Judge, to ask a question. That's absolutely correct. But he has the right not to answer in that situation. He I guess tries to walk away. He's startled. He doesn't know what's going on. And they try to jump him, and then he's not knowing what's happening. He doesn't know about no shooting. It's shocking, Judge.
Got it. Mr. Prosecutor.
All right, I'm gonna jump in real quick. Yeah, the judge and the public defender shouldn't be on the same team. What makes a good team is what I think the first comment was. Is the three of them. The three of them are on a good team. The prosecutor, Mr. Vincent, he's a hardcore prosecutor. He does a really good job. Stands on his soapbox for every single case. And we've all heard it, and you're going to hear it here in a second. Reagan stands on his soapbox for his defense, for his defendant on every single case. Everyone does a really good job. Sorry, I got to hide Michelle. Sorry. I don't know why but the judge understands both of them. They work together every single day. The three of them are a good team in the sense of they all understand each other. They go to battle every single day. And I strongly believe at the end of the day, they're, you know, shaking hands and maybe grabbing a beer together. I don't know, but I think that's what the comment was supposed to mean. Not that the judge and the public defender were on the same side. No, yeah, but yeah, no, I understood what you said, but I think that's what that comment meant. So that's my 2 cents. But this is a serious case. Let's go.
But respectfully, that was the worst rendition of an investigator's report I've ever heard. I mean, what Mr. Reagan at least tried to play out versus what he was trying to use in the investigator's report, that just went haywire. I mean, let's just look at this for what it is. This situation escalated as a direct result of the defendant's actions here. Now, in Mr. Reagan's idea of, you know, what could have happened or what should have happened, because they got shot at, the police ended up finding this individual. They should have come with guns drawn into Coney Island because this individual allegedly may have shot at them. And guess what? Mr. Reagan would have had a field day with that. There was no positive identification. They didn't know who it was. They're drawing guns on him. No, what did they do? They went into the Coney Island because they identified a vehicle that somewhat matched the vehicle that ended up firing shots at them. And what did they do? They wanted to see what was going on. They wanted to investigate. They see this individual allegedly with a gun, and what do? They don't draw their gun. They ask him if he has a CPL. And what does he do? He says no. At that point, they see the gun on him. He doesn't have a CPL. This is where, appropriately, they were asking him questions. They attempted to detain him. And this is where the defendant goes and reaches for his gun. Now, quite honestly, Mr. Reagan may have a different feeling about this. This defendant's lucky to be alive. Reaching for his gun, reaching for the officer's gun. So, Judge, when Mr. Reagan, this should have never happened, and how can you do this to individuals? It was the direct result of the defendant that precipitated all of this. So, Judge, we have an individual who, not even 2 Thanksgivings ago, was either in prison or parole for a manslaughter charge. We have an individual who he's possessing a firearm that he knows he shouldn't be possessing in the first place. And now we have an individual, allegedly, who not only was grabbing for his gun, but was grabbing for officers' guns. And with all due respect to Mr. Reagan, I have multiple narratives regarding the police officers involved in this. The police officers actually warned this individual they were going to shoot him. And I think under the circumstances, at least the way it's written out, potentially they could have. They showed restraint.
Court haven't heard the arguments of counsel. I agree with both sides a little bit. I do think the part in the report about the shooting and the car, it does take you to another direction, and it's kind of like a cliffhanger because you're waiting to see, is there some link to this defendant to the earlier thing? But that loop is never kind of tied in. It's kind of still hanging out there. It's dangling a little bit. But what seems to be uncontradicted though is that if they go into a Coney and they're just on lunch break, if the other part didn't happen and there's a person in line with the outline of a gun that's concealed, that they can inquire about that situation. People don't really want to have a lot of police interaction. If I have a CPL, I've gone through the steps of having the CPL. I don't really want to talk to the police, when I carry my gun lawfully or is concealed. I've concealed it for a reason. But, there was that conversation. Seems that it took a bad turn. If the facts are correct and what's in the investigator's report, the fight over a gun, allegedly reaching for another gun. And, this could have really ended bad and the defendant could have been killed. And if those facts are correct, that would have been a quick investigation and it would have been deemed a good shoot, and that they were justified for the safety of the officer's safety and all of those buzzwords. But luckily, no one was injured. No one was shot. Now that takes us to the bond. The bond is an unaffordable bond. The court does find that in this case, an unaffordable bond is appropriate. I think the magistrate used great wisdom and discernment and putting this unaffordable bond based on the safety of the community. And so the bond will continue.
Thank you, Judge. Judge, can I just say one more thing briefly?
Yes,
I mean,
yes.
it's easy to talk about stuff after the fact. And we don't have, certain body cam, I guess, got knocked off. But when you were talking about an investigation, I guess, and you're talking about, walking up to an individual and approaching a person and asking, do they have a CPL? Is this person detained? Can this person leave? Is this person, because initially he said, yes, I guess it's in my car, according to the investigation. We don't know. Maybe the body cam will show what he really said. But it just seems to me, Judge, that, obviously it's always a lot of situations where, officers approach. And I'm not saying what happened here or what didn't happen because I wasn't there. But I'm just saying, Judge, reading the initial write-up about the shooting and the burgundy and giving chase and losing sight of the car and all that,
Hold on, sir.
That's a bunch of stuff I think that was kind of added in there to give them, like you said, a opportunity to approach when they say they see an imprint.
Right.
And I don't even know what that means necessarily. You see an imprint, of a gun. I mean, that's something, the body cam will show, hopefully, that we can see that they see an imprint, and it'll all come out later.
And then hopefully, we're since we're guessing right now, hopefully the Coney Island has video, and
Absolutely.
that video will be turned over. And
Absolutely.
if there's exculpatory evidence, that the next lawyer can make that argument at the judge of record. Because if all of this, there should be video of this stuff. It's in the Coney Island, so for their safety, they normally have video. So, but with that being said, the bond can.
Yeah, that was they ended it. They ended it. John, I know you just said you had it on mute. I understand your feelings about Reagan. I do. He's very good at what he does. I'm gonna say that. I saw your comment earlier before I started the video. But Reagan's very good at what he does. He's very passionate about what he does. He defends his clients as best as he can. I'm not agreeing or disagreeing with what you're saying, but I have seen him do some things that I've disagreed with. But I've also seen some cases that he's fought harder than anyone else would, and yeah, so it's just really hard to answer or to respond to your comment because I completely understand what you're saying. He's a public defender in a felony court. He sees, Chief Judge McConaughey every day for trying to take down bonds from unaffordable bonds to something that they can hopefully afford. And it's hard. It's hard. He's got a very difficult job. So I don't hate on Reagan for that. It's just part of his job. I hope I'm not losing you as someone who watches. I really don't, because John, you made some really good points, and I agree with you. It's just at the end of the day, he has to do his job to the best of his ability, and that's what he's sworn to do, and he does a good job. Reagan does a good job. There's a couple other people in his office that kind of half-ass it, and you see it, but Reagan does a really good job. And I really did like when Vincent said, "This is the worst thing that I've ever heard defend, Reagan say." Like it was. It was. This is a hard crime, and I'm going to follow this case. I'm going to follow that case, and I'm going to create updates for it. All right, next one. All right, let's move on. The next one is a long one. It's about I don't know. It's about a 30-minute hearing. It is slow for the first, 10 minutes. So if you're watching this now, just fast forward 10 minutes. They're just going through everything. But this defense attorney, since we're talking about defense attorneys, he starts attacking the judge and the prosecutor, just the entire court in general. And he does it respectfully, kind of. but it's very interesting. It's very interesting. Yeah. All right, let's go. I'm gonna try not to pause it, but it's about a 30-minute clip, so I'm gonna have to pause it a couple times, but it'll be minimal.
Good morning.
Good morning, Your Honor. For the record, Jonathan Dicker, I'm here with Mr. Woodcock. He is present at council table to my right. Your Honor, I think this comes on today for actually two things. I think the original purpose of the hearing was a review to confirm that he had had his evaluation done, which he has. I believe probation has a copy of it. And then secondarily, defense has filed a motion to modify sentence, and I do have some additional information provided to me by Mr. Woodcock this morning. I know Mr. Woodcock's wife would like to be heard by the court if the court's willing to hear from her this morning as well. So.
Well, let's see. Let's take these one at a time.
Sure. I do have another hard copy of the evaluation if for some reason the probation officer doesn't have it.
No, have it.
Oh, okay.
Yeah, and it looks like it was sent to me and it was also sent to the court as well. So.
All right, I just got it this morning, so looking.
Yeah, he was
over.
evaluated by the Veterans Administration, Your Honor. I believe that our office also filed the victims panel with the court.
What?
I think we also filed the victims panel previously to today.
I do see that.
Great.
So let me go into the sentencing screen and make sure that that's been updated as complete. It has.
Great.
I recall at the last hearing, there was the appointment was scheduled for the eval, and I did get a copy of the eval that was performed at the VA. Signed by Carly.
We can turn this into that. We can turn this into that. If anyone wants to jump up here, we can talk, because this hearing right now doesn't get good. My English is right good. This hearing doesn't really entertain people for the next like 10 minutes. So if anyone wants to jump up here, we can do a ask me anything type stream. I don't care. But John, I do respect your opinion about Reagan, but please jump up if you're available to, and we can talk about it. I would love to have a conversation with you about it, because I respect you. You've been around my channel since almost day one, so I very much appreciate your opinion. And I'm not trying to call you out or anything. I understand it, and I agree with you. So if you want to jump up here, jump up here.
Good. It was from October 10th.
And there was also an October 18th medical appointment, but that's the second issue for us to discuss.
I'm not sure I see that document, October 18th.
There was it's a separate letter from Dr. Berglund, Your Honor. It was attached to the motion to modify sentence.
Keep pausing it, apparently. Not very many people are. Not very many people I'll pause it for, but Tall Glass is one of them. Welcome, Tall Glass. Glad you're here. Glad you're here.
Yes, I did see that. All right, so which issue would you like to take up first?
I'm happy to take up the evaluation first.
Okay, let's talk about the evaluation.
Sure.
I've had very limited time to completely digest the information, but I am surprised that treatment is not being recommended in this case.
Understood.
And based upon that, I would probably not accept this evaluation with the information that the court has. And also this is it's formatted a little differently than I'm used to seeing. It looks like there was some disclosures.
It's the VA format, Your Honor.
I understand that, but there's still,
Yeah.
it has to meet the standards. I'm trying to see, and Ms. McDonald, I don't know, have you had a chance to look at it in detail?
Well, I got it probably about 10 minutes ago. And I'm looking through it right now. My cursory review of it looks like they're not recommending any treatment, not even a relapse prevention program.
Right.
That's correct.
And can we even tell what information they had on hand for collateral sources that they were reviewing?
I'm sorry. I just didn't hear your question, Mr. Woodcock.
The collateral sources, what information did they review besides speaking to Mr. Woodcock?
Sure. And Your Honor, that I was looking through this myself, looking for that information, and I didn't see it specifically indicated. So I am not aware specifically of what they reviewed outside of what is listed here. I can try to get that information for the court. That being said, I don't have that information today.
Right. That is not going to, this is just not going to work for the court without them meeting the standards that they need for
Understood.
a state certified assessment.
That I understand, Your Honor. And as I said, I can go back to Ms. Hood, who performed it, and make sure that they did in fact review all the appropriate documentation and make sure that that's specified here in the evaluation. And if they didn't, I can make sure that they do and see if that alters any of their diagnostic or evaluative criteria. I think that's not a difficult thing for probably me to get in contact with them and find that out. So I'm sorry that I don't have that information for the court today. So.
And as for the priors that were noted in here, I don't know that there's been full disclosure as to the number of alcohol-related arrests that Mr. Woodcock has been subject to.
And can Your Honor direct me to which page you're looking at?
Well, I'm looking at it says that he had 3 DUIs,
And that's
including
accurate.
this.
That's accurate based on the conviction history that
That
we.
may be the conviction history, but when you get an assessment, there should be full disclosure as to the negative consequences that occurred due to drinking. And we see from all of the records and many that you've presented to the court as well, that he's been arrested many times for driving under the influence. And that is information that should be disclosed to the evaluator. I don't see that that was done here.
I would say false arrests that weren't prosecuted would count as.
I don't believe it's a false arrest, and some were amended to infractions with very hefty financial penalties. So I don't believe they were tossed as not being accurate, or they dealt them in different ways. But the fact that he was arrested and his behavior is consistent with the facts in this case, this is very troubling to the court that this is the situation that was presented to the assessor, and that there is denial by Mr. Woodcock of having any issue whatsoever. And there's doesn't appear to be any insight whatsoever in this evaluation. So the fact that it doesn't meet the state certification standards of what would be expected in this evaluation.
Your Honor, Mr. Woodcock is indicating to me that he disclosed fully to the VA what happened, and they told him if it was not prosecuted, it does not count to them.
Okay, well, then he may need to get an assessment somewhere else that does follow the standards.
Your Honor, the VA is state recognized and state certified. I've had VA evaluations accepted by other courts in the state. There's no indication.
And it may be accepted if it meets all the standards and says what they assessed, what
Sure.
information they don't have.
I agree with
It seems to be off the charts.
I agree with the
inappropriate.
documentation. I agree with the documentation question. In
Mhm.
regards to how they evaluate prior history, I'm not aware of any state requirements that an evaluator take into account cases that were not charged. I'm not aware of any
Okay, they were
statute.
charged.
No, actually, two of them weren't. One was chosen not to be prosecuted. The other one
That's
was
not what that
later.
means. It was charged. It's on his record. It was later resolved.
Nolo
think looking
prosequi
at the
means
triple I.
chosen not to be charged, Your Honor. The triple I is not accurate. The court records are. We've supplied the court record. Nolo prosequi means the prosecutor chose not to file the charges. That's literally the definition of the phrase.
Mhm. Okay, so let's.
All right, so this is starting to spice up a little bit. This defense attorney is trying really hard for his client, and rightfully so. He's his client is a veteran. He served, and he's undergoing a lot of treatment for a lot of different things that happened to him while he served. Unfortunately, I don't want to spoil it, but I don't. I've been reading the chat, and I don't know where exactly I am in the video. I just wanted to a good pause, but he has a drinking issue, and that's why he's in court. I think he's on his third DUI, so it's a serious issue. It's a serious issue, and his defense attorney does a really good job defending him. And maybe he goes a little overboard here in a minute. I don't know, but it's great. But again, there's not a lot of people here. I don't generally get a lot of viewers in this like middle of the day hour. But if anyone wants to come up and discuss anything, just click the link. Hold on, John. John, you're the one I want to come up. No, you would not. You would never be sad and boring. Like, no, I completely agree with you. I completely agree with you on Reagan. He has a tough job, and he tries to make his clients look a lot better than they actually are. It's his job. So I'm never going to disagree with you on that. I will never disagree with you on that. And I love your comments. So, and I can see throughout the comments that what I have seen is people have been very respectful of your opinion, because it's your opinion, and I appreciate you saying it, because it creates conversation, right? This is what these channels are supposed to be about. We're supposed to create conversation. All right. Yeah. No worries, man. No worries. You're still family here, man. I think half of us agree with you, and well, I think most of us agree with you. So I hope you're not getting any negative feedback from what I've seen. You haven't. Yeah, you're allowed to have your opinion, dude. So that's why I was hoping to bring you up, because I wanted to have a conversation about it. Because you were passionate about it early, and I really wanted to hear what you had to say. But it's okay. It's okay. All right, let's finish this. All right, well, let's finish it. There's still like 20 minutes. This is again a slow burn type of case. This is the defense attorney's All right, let's just go.
It's just from this point, we don't have a good evaluation.
Understood. And I can get that information and find out what exactly they reviewed. And as I said, I can get that information from the VA. And if it's something that they haven't considered the appropriate documentation per the state guidelines, I can make sure that they get it, see if that changes their recommendation. If it doesn't, then we'll be standing by the evaluation, because they are a chemical dependency treatment provider who has the capability and the criteria to make such decisions.
All right, Ms. McDonald, your response?
Well, Your Honor, in looking forward or through this evaluation, the one thing that did catch my eye is that it did say at the bottom of the evaluation that if the court still required SUD treatment, then he would be appropriate for standard outpatient treatment. So it seems to be a little.
Which page are you looking at?
Yeah, if court requires SUD treatment, veteran be appropriate for core team referral for standard outpatient SUD treatment. And I do see
that is second to the last page.
Actually, I think it's the last page.
Or it is the last page. Yes, it's just a couple paragraphs above the signature line.
And we have no issue with that part of the recommendation either. I think that's based on their criteria and their assessment, and I think that's
what level.
it just says standard outpatient SUD treatment. It does not indicate. Well, it's. I'm assuming the core team would then make that referral, because it sounds like there's a that works with a veteran program called CORE that then makes that referral for whatever they think is appropriate at that time. If that's something the court is then requiring. But if the court wants to see a more thorough evaluation from the VA, make sure it's meeting their criteria, I think that's probably the first step. And I've got no problem getting that.
Is the city satisfied with this assessment?
No, I'm not satisfied with the assessment, because it doesn't have an indication that they read the police report. It doesn't have an indication that they viewed all of his history, including his III history. Because I do agree with the court, even though there were cases that were charged as DUI and amended to something different, those still count as an alcohol-related offense, which should go towards their assessment review. Even though it's not a conviction to a straight DUI, I think those still need to be considered under the Washington standards.
And I think those were, Ms. McDonald, the ones that I think weren't considered were the ones that were misidentified on the III, and when we got the court records to the court, they show that they were nolo prosequi. They're miscategorized by the III. In fact, the courts in Georgia have been attempting to get them corrected for years, and they're not. We've provided proof of that at sentencing. So.
Well, we need to find out from the evaluator exactly
absolutely.
what it is. Yeah,
absolutely.
So,
yeah.
And I think unless and until we have that done, I don't think that under the statutes that we can accept this evaluation.
That's fine. I've got no issue getting it updated.
All right, well, one of the obligations was to get an assessment, which he does have it. The court is not accepting it as presented, but he did submit to getting an assessment.
Mm-hmm. Yeah, I don't think it's Mr. Woodcock's fault that this isn't in the format that we would typically expect or wasn't performed in the way we would typically expect. He did what the court asked him to do through the pathways that he has available to him. So getting the paperwork to match what we wanted to match is something that I can help the VA work on. So.
All right, we're only halfway through this. I walked away for about 2 minutes, so
all right, and
I don't think I missed any of the
setting
good
that
parts yet.
aside, that will
But it's
be
about to get
resolved,
Get
down
good.
the road. This is a
Right.
5-year jurisdiction, so there's plenty of time to make sure we get that done correctly. There is the issue of his sentence. I have the request to modify.
Yes, Your Honor. And given the additional information Mr. Woodcock presented to me today, I want to make sure that I'm
What
making,
information is that was presented
it's
today?
just the dates of some upcoming appointments that he has, and he's got a bunch of them. He's got appointments coming up for.
All right, I'll pause it for that. So, from what I remember, now this happened yesterday, I believe, maybe the day before. This is a sentencing, I believe. He's already pled to whatever he's pleading to, and this is the sentencing. So this is his third DUI. I believe he pled guilty. Okay, so if this is a probable cause, then I'm way off. But I really don't. I think it's a sentencing based on what is about to happen. They're trying to. It's a sentencing because they're going to start talking about jail time here shortly. I might have just ruined it. So they're talking about what he's going through and why they need to delay sentencing. That's okay. Now I just got caught up. Sorry, I just kind of mumbled a little bit. John, respect everyone, express their operating opinion, John, we all love you, man. No one here dislikes you. No one here dislikes you. Your opinion wasn't even wrong. It was your opinion. I just wanted you to come up because I wanted to have a conversation about it. You didn't say anything wrong. You said you didn't like a certain defense attorney, and I understand that. So, John, relax, man. If you want to come up, that's why I sent you the link. Let's have a conversation. conversation. Like when things get emotional, it creates good conversation. But no, you didn't do anything wrong. You literally nothing wrong. You didn't hate on me. You didn't hate on the channel. You didn't hate on anybody here. You're fine, man. You're fine. All right, but yeah, this like I said, this is a little bit of a slow burn, but this defense attorney, he's about to get emotional too. All right, let's go.
Neurology, he's got appointments coming up for CAT scans, appointments coming up for endoscopies, radiology scans, as well as appointments for mental health. All of those through essentially November and December. As I indicated in the motion, Mr. Woodcock was exposed, unfortunately, during his service to asbestos, and is currently being evaluated for any number of asbestos-related conditions. He has some severe stomach issues that may be related to any one of a number of types of cancer, not the least of which would be something like mesothelioma. He's being evaluated for those actively. He's got appointments and scans coming up through the next period of time. In addition, he does suffer from PTSD as well as depression, and I believe anxiety as well, not the least of which was from his service, but also from the unfortunate loss of his son.
I saw that in the email. I'm very sorry about that.
What I believe Dr. Berglund is suggesting is at the very least a delay of the imposition of sentence until we know what's going on. I think that's probably the best solution. And so what defense is going to request at this time is essentially a 60-day extension of the commitment date and a new review just prior. That'll give me enough time to get the evaluation sorted out, and hopefully it'll give us enough time to get some more diagnostic information. We can figure out what Mr. Woodcock's dealing with and whether or not imposition of his sentence will cause actual harm or potential harm, whether or not we need to talk about modifying it to a home monitoring type sentence or something like that. It'll just give us time to get more information. It'll leave him able to do his doctor's appointments, et cetera. As the court has indicated at previous hearings, the court found Mr. Woodcock was not a flight risk. Mr. Woodcock's dutifully appeared at every single court appearance. He's taken this extremely seriously throughout the entirety of the case. I don't think the court should have any concerns about him not appearing for any review hearing or not turning himself in. This is about his health, which I think is to a certain degree, this is about something bigger than his DUI sentence. This is about his life. And it's something that I don't think we can understate. His doctors indicated that the imposition of the jail time at this moment would pose a substantial risk to his physical and mental well-being. That's the language in the statute that allows for the court to frankly suspend any mandatory jail time. I'm not asking the court to do that.
It's not applicable to Mr. Woodcock's situation per the statute.
Well, and that's because Mr. Woodcock is technically being sentenced for a first offense within
That's
7
right. So that doesn't apply.
And it only would apply, it would only apply to the mandatory minimum portion of it anyway. What I'm asking the court to do, given this information, is simply delay the imposition of sentence, setting out his commitment date by 60 days to give us the time to get more information. And also, I think it'll solve the evaluation issue. And if we can get the evaluation issue sorted out sooner, he can also get the treatment started if there is any treatment to be done. And then we should know more. The court's also aware, I know, that there's a pending appeal at this point. The notice of appeal has been filed. Mr. Zwanich is handling that. And who knows what the outcome of that's going to be. That's really not necessarily anything that is, I guess, it doesn't necessarily go into the mix. That being said, it's part of the calculation in defense counsel's mind, because we've made a motion to stay sentence that was denied at the time. At this point, I think we've got sufficient medical reasons to ask the court not take him into custody tomorrow or order him into custody tomorrow. If the court's not willing to move the commit date, given the information, what I'm asking the court to do is convert the sentence to home monitoring. The court does have the ability to do that. The mandatory minimum for him would have been 2 days in jail or 30 days home monitoring. The court could very easily convert the entire sentence to home monitoring. The court could extend it to a full year of home monitoring. The court could do whatever it wanted to. Either way, the most important thing to me is that Tim get his scans done, Tim get treated. On a personal note, as a 2-time cancer survivor, you don't mess around with this, Your Honor. I went through cancer twice in 2020, and it was the worst thing that ever happened to me. I beat them both, and I'm 3 years
Well, we're
cancer
talking about
free.
Mr. Woodcock here.
I
And with all
understand.
due respect, I'm concerned about, I'm going to hear from the city on this motion.
Before
Yeah, the defense attorney is testifying hard. Started bringing up his own life. He tries hard. He tries hard, and we haven't even heard the good part yet. I know it's a long hearing. It takes a while to get to the good part, but I can't just play the good part. But this attorney does his job. I yell a lot. Thank you for stopping by. It's been a while since I've seen you too. I appreciate you coming by. Beverly, thank you. Thank you. Thank you. Thank you. All right. All right. I think I accumulated all the seconds I need to pause. So let's go.
the court leaves defense, is the court willing to hear from Mr. Woodcock's wife, who wanted to be heard from today?
I don't know that that's necessary. Ms. McDonald?
Yes, the only thing that I haven't heard today is what the dates of those appointments are. I was able to glean from an attachment to the evaluation that his CT scan is scheduled for the 3rd, but I don't have the other appointments. I don't know if 60 days is going to be appropriate. I don't know how far out they're spaced. Could be something where a temporary release would be appropriate if there's something in that respect. But I think we need to have that information.
And I've got that here. The CT scan is scheduled for the 3rd. I've got a neurology imaging scheduled for November 29th. I've got a December 6th primary care follow-up. I've got a November 6th Edmonds outpatient follow-up. And then Mr. Woodcock was also indicating he's got an endoscopy scheduled. December when?
December, it's in the 12th.
The 12th of December.
I think it's 12.
So
What was there? You said there's a primary care and then an outpatient. What is the difference between those?
Your Honor, it appears to be that one is, they're with 2 different providers. So I'm assuming that one is related to mental health and one is related to physical health, but I don't know specifically just from these. These are just the VA appointments that are scheduled through the Edmonds VA clinic. I just have the dates and times. I don't think that TROs would be appropriate, given the fact, number one, that Mr. Woodcock may or may not stay locally if he does get committed into custody. And number two, the fact that sometimes these sorts of scans come up with additional treatment that's needed, sometimes quickly. The reason I asked for 60 days is because I know that the last thing he has scheduled is roughly in the middle of December. That gets us enough time to get these things done, for me to get the evaluation information, and to hopefully get the results of things so that I can give the court more information. If we set this into the last week of December, second last week of December, or even the first week of January, I should be able to come to the court armed with much more information at that point. And we can set a commit date, the next day, a week after, whatever the court wants to do. What I don't hear from the city is a compelling reason why not to do that. I understand the city wants to get sentence imposed.
The court wants to get sentence imposed. I felt it was an appropriate sentence based upon the facts and
Sure.
based upon Mr. Woodcock's history.
Sure, I
So
understand
the
that.
court is inclined to push ahead with the sentence that was imposed. I don't know when these medical appointments were scheduled or how they were, what requests there were to either be getting him in as soon as possible, or if he's been working through this all summer trying to get these in. I did see in the assessment, he said he doesn't have mental health issues, which is one of the reasons that you put forward to the court. He specifically told the evaluator that he didn't. So I'm concerned that this is a potential gaming of some medical reasons.
Your Honor, with all due respect.
All right. Now I can finally pause it. This is when the defense attorney goes off. The gaming of the medical reasons for the court is when it goes off. But it's a good time to pause because Miss Manny just stopped by. Everybody, If you don't know Miss Mandy, you should. She's good people. She has a channel. Miss Mandy, I can't tell if you have a wrench because I'm in studio right now. If you do, please drop your link. If you don't, can one of my mods please drop her link? All right. This is when the defense attorney actually gets this is when he gets paid his money. So enjoy the next couple minutes of the defense attorney yelling at the judge and the prosecutor. All right. Let's go.
I'm making a record here, so I'm concerned.
Your Honor, you're
And-
making an offensive record to somebody who's been through military service and lost his son to say he's gaming the system by saying
I
it's
am
PTSD.
concerned that it's the PTSD he's denying in that record. I'm
Most
looking at
people
two
with PTSD
inconsistent
deny
things.
it.
I'm looking at two inconsistent documents, okay? I firmly believe that PTSD may be a situation, but I'm not seeing it what I have before me. And I'm seeing two different positions by Mr. Woodcock. And I'm concerned looking at this, and I'm concerned looking at the behavior that I saw in his DUI arrest, which parallels the behavior in all his prior DUI arrests, which is to deny and deflect and
I'm sorry. I'm always going to pause for Detective Rachel. Just how it is. You're going to have to deal with it. I'll always pause for Rachel. Rachel, welcome. Thank you for stopping by. I hope you're enjoying the video. And Judge King today, I hope he enjoyed his omelet. I left before he ate, so I hope he enjoyed it.
I see a bit of that going on here. So I'm concerned, and I want Ms. McDonald to have her say in this as well. I don't know that we just push this out. You asked to set this until early next year. I denied that request previously. So I'm letting the city make their record as to why or why not. This should be continued another 60 days.
And Ms. McDonald, would the city object to EHM with scram as opposed to incarceration, given the medical issues we're looking at?
Well, yes, because we opposed the EHM with Scram when you requested at the time of his sentencing last month. I certainly understand that he may have some health issues. I do echo the concerns of the court, which was clear, I think, when we made our sentencing recommendation as well. In looking at the dates that that you put forth to the court, I don't see why we couldn't do a temporary release so that he could go to those appointments, not necessarily the primary care, but the neurology and the endoscopy. His CT scan is in 2 days. I don't see that we could probably delay till after the CT scan, but the other two, I think, could probably best be done with a temporary release.
Why not his primary care? That's where he finds out the results of the scans and finds out what his next method of treatment is. That's where he finds out if he has cancer.
Those could be something that is done with a telehealth appointment through the jail.
Through the VA?
I don't know what the VA capabilities are in that respect. So certainly that would be
The lack
something to
of
ask them. But
humanity in this room is startling.
no, Mr. Dichter, you have to
shocked.
understand that there is a defendant before the court with a significant number of alcohol-related driving offenses, and he has placed the public in danger each and every time. There is a level of punishment that is expected in that respect, and he has to comply with the sentence of the court. Certainly, we have to take into consideration his appointments. I don't have a problem taking those into consideration, but working with those and also working with the orders of the court. I think there has to be that medium. But I don't think electronic monitoring for someone who's before the court on their 5th DUI is appropriate.
3rd DUI by court record. Again, I will
understand your position on that, but
I'll continue to say that until somebody from Georgia comes up here and tells me otherwise, because Georgia has already told us those weren't real. The reality is that we have a defendant before the court who has had his criminal history misstated, who was convicted after what, based on the appeal that I know is going to be filed, was an unfair trial with an unfair jury and an unfair judge who allowed a prosecutor to get away with prosecutorial misconduct. The fact that I even have to ask for someone who is undergoing treatment and consultation to determine whether or not they have a life-threatening illness after serving our country, to have a sentence delayed when they have not missed court in 2 years and have had 0 violations of any terms and conditions. The fact that the city recommended a 10-day sentence, then asked for a 9-month sentence. The fact that the court imposed a 6-month sentence and is now accusing the defendant of gaming the system is ridiculous and offensive to my concept of what our system is. This is wrong. There is no other word for it. This is wrong.
Yeah. What do you think? What do you think? What did she say? I just highlighted a message. I think they said his 5th DUI, and they're saying it's his 3rd. Prosecute whatever misconduct. It doesn't matter. What do you guys think? Is the defense doing a really good job? Is the prosecutor doing a really poor job? Is the prosecutor doing a really good job and the defense is just yelling and trying to be the louder person in court? What do you think is going on right now? I feel for this guy. I do feel for this guy. If everything the defense is saying is true, which I don't know. But if he is saying the truth about everything in this case, I do feel really bad for the defendant. But he has an alcohol problem. That's the plain and simple part of it. He's got an alcohol problem. You can't keep driving. So yeah, please let me know. Please let me know what you think. I've got mumble brain right now. So yeah, let me know what you think about this case. Who's right? Who's wrong? Is the defense a try hard? Is the prosecutor a try hard? Is the judge just trying to stop everything from happening? Let me know what you think in the comments. All right, let's finish this up. We got about 10 minutes left of this. Just so you know, there's still more to come. I just paused it when there was a stop and talk.
Your outrage is noted for the record.
And justified for the record.
All right. So right now, we have the issue to deal with these medical appointments. And Mr. Woodcock has been sentenced to a 6-month term. Obviously, the appointment on Friday is close in time.
We've got one on the 6th as well, Your Honor.
Lolly's here. Lolly is another person I'll pause for. Hey, Lolly. Good to see you.
I think that's December, correct?
No, there's one December 6th and one November 6th. There's November 3rd, November 6th, November 29, December 6th, December 12th.
Is the 11/6 primary? Is that?
November 3rd to be primary, but it's literally Monday. I'm going to ask the court to let him go.
And who is that provider?
Looks like Primary Care Jernigan is the name. Edmonds Outpatient Clinic, Edmonds VA Clinic. Doesn't specify the specific nature of the appointment.
Likely the results of the CT scan is my guess.
That's my guess too, but I don't know for sure.
What I'm going to do is reset this matter and delay decision, and we'll come back and we will have a better idea in, I'm talking a week or so, to know what occurred. So the letter we have from Dr. Berglund, that is also with his primary care clinic.
That is the internal medicine primary care. So that's internal medicine, but yes, that's his primary care doctor who's kind of coordinating everything.
but not who will be seeing him on Monday.
I don't think so, no. That looks like Jernigan, so, but it looks like he's got multiple doctors. He sees Dr. Berglund again, it looks like in December specifically.
All right, what date? We could set this the 6th. Ms. McDonough, we have equally busy calendars, the Monday, the 13th, or Wednesday, the 15th. Do you have a preference? So I wish you should check your calendar.
What time would those hearings be?
We probably calendar them for 9.
I would only be available on Monday, the 13th. I'm not available.
Yes, I eat Skyline chili. It's been a while since I have. It's a Cincinnati staple. You got to eat it. Skyline. There's also another brand, Gold Star, and we eat Cincinnati chili. So yeah, Skyline is a staple. It's as much of a fast food as McDonald's is or any other fast food. So yeah, I can't tell you the last time I had it. Since I moved to this apartment back in January, I think I've had it twice. So twice in over 10 months, I've had it twice. But yeah, Skyline is something you eat when you're from Cincinnati. It just is, and it's delicious. But it's fast food. It's fast food. But yeah, it's really good. Hopefully that answered your question.
Available on Wednesday, the 15th.
We could also, well, it would, so the 13th, let's see.
Now I feel like I'm pausing way too much. Yeah, I don't know what's going on. I don't know. I was not there when that happened. I generally keep Judge Simpson. Um, that's at the bottom of my list. Judge Simpson's courts at the bottom of my list. The very top of my list are the courts that delete the second they stop. The second they stop recording. I probably should finish my sentence. Judge Simpson never has done that. He's done it maybe twice over the last, I don't know, 6 months that I've been watching him, that he's deleted the clip right after. But he generally would keep his hearings up for a week or two and then he would delete them. Yesterday, there was apparently something that happened. I don't know what happened, but I don't know what else to say. The rumor on the street is he's done with YouTube. I have no idea what happened. If anyone knows what happened, please leave a comment and tell me because I don't know. I've reached out to a few people. No one really knows. So if anyone knows the answer to that, please let me know. All right, there's about 6 or 7 minutes left of this. I don't want to pause it again. And let's just go. Let's just finish this. All the good parts are over, just so you know. So if you're rewatching this from before, yeah, now they're just trying to figure out what his treatment's going to be. But, he's going to jail. He's going to jail.
I would also
All
be
right.
available on the 20th or 22nd, just not the 15th, Your Honor.
All day on the 15th is out.
Well, I can do the afternoon. I'm hard set in.
I don't know if Miss McDonald can.
Yeah.
She's not typically calendared. For
I'm
the
just hard set
afternoon.
that morning in an in-person hearing in Arlington, Your Honor, at 9.
Miss McDonald, do you want to do an afternoon?
So either one of those days, I would prefer to do the mornings, Your Honor, because I'm not scheduled to be in Lake Forest Park in the afternoons and usually get farmed out to another jurisdiction if necessary. Certainly if the court orders it, we'll make sure that someone's here.
Well, let's do the 13th. I'm just concerned these take a lot of time and we have calendars, which will back everything up.
And if the calendar is normally at 9, I'm happy to have us set at like 10 and we can just come at the end or to
Well,
the end of the calendar.
it just pushes it. It gets all ugly in the morning.
I
So
understand.
November 13th at 9 a.m.
And I'll do the best I can to get an updated evaluation by then as well.
All right, and then Mr. Woodcock will need to sign releases. I don't know that he's done that yet for Mr. Mitchell. So
No,
that's,
I do need him to.
Oh, sure. If you have one, we can.
I
sign that.
do.
Great.
His name and then the name of the clinic on also.
Yes, that's just the VA or, no, that's good. Yeah. So just write VA.
the court is not ruling on the issues of converting or delaying sentence beyond that hearing date.
Understood. And I appreciate that, Your Honor. What's the next quick date?
All right, we're pretty much at the end of this.
Mhm.
I told you it was a long one. There was that like 5 minute in the middle that was
Do you need a
interesting,
copy of that for me, please?
but we have a
Mr.
veteran.
Victor, I'd ask that any documentation submitted be done at least a couple days in
They're
advance,
still
if
fighting.
I'll get it.
possible, so I have time to review it before the,
As soon as I've got it, I'll get it to you.
thank you.
Sorry about the late yesterday email, but I'll get it to you as soon as I've got it.
And you submitted the appointment with the assessment. So if you have appointment schedules, you can also submit those documents as well.
Great. Wonderful. Thanks, Sean.
Thank you.
All right, I think that's it. Yep. All right, that's it. Yeah, there was that little window where that defense was trying really hard and trying to admonish the court and the prosecutor, which I applaud. I'm glad the defense attorney did that. The prosecutor doesn't pull any strings. Sorry. Still not feeling well. The prosecutor doesn't pull any punches. Doesn't do anything she or he would, in that case she, is fighting for the state, right? So the prosecutor deserves that right too. And I completely understand that. And I like the passion behind the defense attorney, even though it was his 5th DUI. They're saying it's his 3rd because 2 should be thrown out. It's his 5th DUI. Even if 2 are thrown out, it doesn't matter, right? The facts are still there. The facts are still there. If I'm okay, I'm not going to go into it. I'm not going to go into it. All right. I am done for now. I have a lot of clips I'm working on right now. I might have another video tonight. I'm hoping to have another video tonight. So hopefully we're going to have another video tonight. But in the meantime, Natalie D is about to start streaming. Jump over there and say hi. Just jump over there and say hi. You don't have to do anything else. Just be like, hey, Colin sent me. Hi. She has a good channel. So say hi. But until I see you later tonight or first thing in the morning, that's kind of what my timeline is right now. So thank you for coming. Until next time, bye.